Hello, I'm David Roger, General Counsel for Las Vegas Police Protective Association. Today, the U.S. Supreme Court handed down its decision in Chatrie, Chatrie versus United States. And it is a case that we've been waiting for, dealing with the validity of geofence search warrants. And so let's look at a previous case that kind of gave us some indication as to which way the court would be headed. And so it's Carpenter versus United States. It's a 2018 case that we've discussed in the past. And in that case, the question was, do citizens have a reasonable expectation of privacy in their cell site information? And so in other words, do police officers or are police officers required to get search warrants when they get cell site information? And the answer in that case was a clear yes. Citizens have a reasonable expectation of privacy in their travels and certainly in their cell site information. And so the Chatrie case, it was really kind of an extension. And in Chatrie, the question was, do citizens have an expectation of privacy in their location history on their phones? And so, as you know, anytime you download an app, it prompts you to answer whether you want location services on. And so, in that regard, Google keeps historical data from location history information, and this information is uploaded from your phone, every 2 minutes and sometimes even more frequently. And the precision of this location history is so much better than a cell site information. It can locate suspects or citizens within 2 meters. It can tell elevation, whether the person is on the first floor or second floor of a building, and so it's a valuable tool for law enforcement. And so Google and law enforcement have developed this 3-step process for search warrants. And the first step is to request information from a geographical area that was the location of a crime for a specific time period. There's a data dump, and then law enforcement, along with Google, narrow the inquiry down after 2 more steps. And so what the court held today was that, and no surprise, that a citizen has a reasonable expectation of privacy in their location history. Therefore, law enforcement and the Fourth Amendment requires that law enforcement obtains a search warrant for that information. All that is well and good. It's something that we expected, especially after the Carpenter decision, but it sent the case back to the circuit court to look at the search warrant to determine whether the search warrant was vague, overly broad, whether the search warrant was reasonable, whether the good faith exception should apply to those search warrants. And so all of those questions, and really important questions for us as law enforcement, will kind of be out there lingering until another decision comes down. And so the circuit court will review the search warrant, and assuming that there's a decision and someone appeals, it may very well get back up to the U.S. Supreme Court, but that will take some time. So for today, what we do know is that if you want cell site information, you have to get a search warrant. That's Carpenter versus United States. And Chatrie versus United States says that if you want location history from Google or I guess any other provider that keeps this data, you need a search warrant because a person has an expectation of privacy in their travels. And so It's an important decision, but it certainly doesn't answer all of our questions. Thank you very much for watching our videos. And if you have any questions, contact me at droger@lvppa.com. Thank you.
111, 110.